Section 4.5.6, Arrest Law. Hello, I'm Dr. Adam McKee. Today, we'll explore the concept of arrest as it pertains to the Fourth Amendment of the United States Constitution, which protects individuals from unreasonable searches and seizures. This protection extends to arrests, a critical aspect of law enforcement's interaction with the public. An arrest occurs when law enforcement takes an individual into custody with the intention of charging them with a crime. This act is considered a seizure under the Fourth Amendment, thus requiring that it not be unreasonable. While the Constitution generally mandates that an arrest be made with a warrant, the reality is that most arrests are made without one. Regardless, for any arrest, whether with a warrant or not, officers must have probable cause. This means they need reasonable grounds to believe the person has committed or is about to commit a crime. Probable cause is the legal threshold needed for both issuing arrest warrants and making warrantless arrests. When seeking an arrest warrant, officers must present evidence through an affidavit to a judge who will determine if the evidence meets the probable cause standard. An arrest warrant must clearly identify the individual and the charges. However, warrantless arrests are typically permissible under the law when an officer has direct evidence of a felony or, in certain cases, a misdemeanor. Historically, common law allowed officers to make warrantless arrests if they had probable cause to believe someone had committed a felony. For misdemeanors, the crime had to occur in the officer's presence. Today, while many jurisdictions maintain these principles, others have expanded the scope through statutes allowing warrantless arrests for specific misdemeanors not witnessed by an officer, such as domestic violence incidents. A significant aspect of arrest law involves the requirement for an arrest warrant to enter someone's home. This safeguard is crucial for protecting privacy under the Fourth Amendment. However, exceptions exist, such as exigent circumstances, situations requiring immediate action to prevent harm or ensure officer safety, that allow officers to enter a home without a warrant to make an arrest. In the context of domestic violence, research and subsequent legislation have influenced how arrests are made. Studies indicating that arresting the primary aggressor can prevent further violence have led to laws requiring officers to identify and arrest the primary aggressor. These laws have enabled officers to make arrests in domestic violence cases without a warrant, even if they did not witness the misdemeanor, reflecting a significant shift aimed at enhancing victim safety and holding offenders accountable. Despite these laws, challenges persist in how effectively police handle domestic violence cases, with critiques focusing on the consistency and thoroughness of law enforcement responses. This underscores the ongoing need for training, accountability, and community engagement to ensure that arrest practices not only adhere to legal standards but also effectively serve and protect the public. Arrests are a fundamental component of law enforcement's duty to maintain public safety, balanced by the legal requirement to respect individual rights. Understanding the nuances of when and how arrests can be made according to the Fourth Amendment is essential for upholding justice and ensuring that the practices of law enforcement are both effective and fair. Thank you for joining me as we navigated the complex topic of arrests under the Fourth Amendment. If you found this discussion enlightening, please like, subscribe, and share your thoughts in the comments below. Stay informed and engaged as we continue to explore the critical issues at the intersection of law enforcement and constitutional rights. This has been Arrest Law with Dr. Adam McKee. Keep learning and discussing as we delve deeper into the vital topics shaping our legal and justice systems.